Good afternoon, everyone, and thank you for joining us in this virtual workshop titled LGBT Employees and Seniors in the Workplace. My name is Robert Emery, and I'm a founding member of the Coalition for Aging LGBT. Our mission is to improve and protect the quality of life of older LGBT adults in the 4 counties that make up North Texas. And to that, let us continue our critical mission to support, advocate, and lift up our LGBT seniors in North Texas. We are pleased to present to you today a fantastic workshop about the new rights LGBT employees should know and why they are important and why they might be in jeopardy. Joining us today is Shelley Skeen, Senior Attorney at Lambda Legal, and Shannon Mentor, Legal Director for the National Center for Lesbian Rights. We are thrilled to bring you these 2 wonderful people and their years of experience. And now, Shelley and Shannon.
Great. Thank you for having us, Robert. And hey, Kim, how are you? And so Shannon and I are going to talk a little bit about what happened about a week ago with the Supreme Court decisions, and then also about what happened yesterday. So Shannon, do you want to talk a little bit about the history of Title VII, what it does? And I'm happy to just chime in as you go forth and conquer.
Sure. Yeah, and thanks so much for having me on this and for all the work that you do. I was born in Texas and recently moved back to North Texas, so I really appreciate this group on a very personal level. So the big Supreme Court decision in Bostock was about Title VII, which is part of the Civil Rights Act of 1964. And that is important because we should remember that just how much our community, the LGBTQ community, has benefited from and owes an enormous debt to the civil rights movement and all of the advocates, the activists, the elected officials, individuals who worked so hard to make the Civil Rights Act of 1964 a reality. Where without that statute, which was primarily driven by the Black civil rights movement, we wouldn't have the decision that we had in Bostock. And same for the women's movement. Like, we really have, those 2 movements have done the heavy lifting and the hard work of getting this fundamental foundational Civil Rights Act passed, and then getting the precedent set that we've then come along and used to protect LGBTQ people. So that's something we sure should not forget. Well, Title VII was part of that act passed in 1964, and it is really an important part of the act because it prohibits workplace discrimination based on race, sex, religion, and national origin. And it is that piece that prohibits sex discrimination that has turned out to be so critical for LGBTQ employees and workers. And there's decades now of cases that are brought by transgender workers and by LGBT, lesbian, gay, bisexual workers that have laid a kind of foundation for what the Supreme Court held in Bostock. But Shelley, you jump in, and that's just kind of the basics about the statute and the history of it.
Yeah, sure. So since some of us might be a little bit older here, y'all probably remember over the years our quest in this community to try to get ENDA passed, which was the Employment Non-Discrimination Act. And so Title VII, if you look at, let me kind of step back and give you a little bit more of an overview. There are 8.1 million right now LGBT workers in the United States. Less than half of them are covered by protections in the workplace by their state laws. So Title VII is a federal law, and it covers employers that have more than 15 employees. So even though we got which is really a landmark decision that we've been working for so long, with respect to being able to be employed in the workplace. Only about 20% of the employers in the United States are covered by Title VII because the bulk of employers have less than 15 employees. So as a sort of shout out to this group, what we need is we need protections here, state protections, which we don't have in our state. Texas is one of the 22 state, well, one of 28 states, now that I can do my math. I'm a lawyer, not a mathematician, but there's only about 22 states that have protections for sexual orientation and 21 states that have protections for transgender folks. And so even though we got a good decision, we still need that for our community, both on a local level and the state level. And Shannon and I will talk about that a little bit more. But so that's kind of the lay of the land. And then I'm going to let Shannon give you some of the facts in the cases, and then we can go into the court's reasoning. And I know that we're looking at about 30 minutes here, so we're not gonna go into the heavy duty details. We want to get to your questions so that you know what you feel like you most need to know as we leave today. So Shannon, maybe give a little bit about a couple of the cases, pick either or what have you, and then I'll chime in.
You bet. Well, this should be short and easy because the facts in these cases were super straightforward. There's three cases that were all heard together. They were consolidated into one case by the Supreme Court and issued just one decision that applies in all three cases. But two of them were gay men. One guy from Georgia and one guy from New York. The Georgia guy was a social worker. The guy from New York was a skydiving instructor. And in both cases, what happened is they were both great employees and no problems until the employer found out that they were gay. And the minute that was disclosed, they were both fired. So there was no dispute about what was going on, and the Supreme Court in its decision said that. It said, the facts here are undisputed that these people were fired. These two men were fired solely because they were gay. That was it. And similar, the third case was a transgender woman, Amy Stevens, from Indiana, who had worked for several years at a funeral home in her small town in Indiana, and had been working as a man and then came to terms with being a transgender woman. And soon as she told her boss that she was going to need to transition and she would be living and working as a woman, the boss said, well, that's not going to work out, and fired her. So yeah, facts are real straightforward.
I think it's also important to note too, change happens over time. And so both Don Zarda, who was one of the gentlemen in one of the sexual orientation cases, and Amy Stevens have passed away. So by the time the decisions came down, neither one of them got to see what the court did. And so that's another reason why we need that legislation locally to give us those rights that we don't have. And so I'm going to harp on that a little bit if you hadn't noticed already. So what did the court do, and what was really the question before the court? The question before the court was, does this term sex in the statute, which prohibits discrimination based on, Shannon said it, race, color, religion, national origin, and sex, does that term sex, which was not defined at the time that the act was passed, does it include sexual orientation and gender identity? And this is the first time that the United States Supreme Court has gotten a weigh in on this. And for several years, transgender status has, for the most part, been covered because of a case that came down in 1989 called Price Waterhouse, and I won't go into the specifics. But so your transgender status, if you did not meet the stereotypes for whom that were the norms at the time. So for example, women were supposed to act like women. They were supposed to be ladylike, wear makeup and high heels and whatnot. And men were supposed to be more manly. So if you didn't conform to those stereotypes, the Price Waterhouse case said that and you are fired because you don't conform to those stereotypes, or you're not hired, or you're not promoted, then that is discrimination on the basis of sex. So that's been there. And now we came forward and we're looking at both of them together before the Supreme Court. So prior to about 2017, sexual orientation was not covered by Title VII. There was a case in, I'll do a plug for Lambda Legal, who I work for, and Lambda brought a case called Hy-Vee versus Ivy Tech in the Seventh Circuit. And initially, the Court of Appeals said, we don't find that there's coverage for sexual orientation because sex does not include sexual orientation, although all of us would certainly think that because who we form an enduring relationship with is based on our sex. So it seems like if we're discriminated against, sex would be there. And that's ultimately what the United States Supreme Court said. I think it's pretty simple is, is sexual orientation encompassed within sex? Is transgender status encompassed within sex? Well, sure it is, because it depends on the sex you're assigned at birth. So getting off track, in 2017, the Hively case came down, and the Court of Appeals initially said, look, there's no coverage under Title VII. And then a little bit later, there was what's called an en banc decision, and the en banc court, which was all the judges, said, you know what, we're in different times now. We've had a litany of case law that has looked at Title VII and said that Title VII has covered things that weren't intended back in 1964, such as sexual harassment, same-sex sexual harassment, not conforming to stereotypes. Therefore, we're going to find that sexual orientation is covered. And so that is kind of what set up the reason why we got to the United States Supreme Court, along with the Zarda decision, which was out of the Second Circuit, which was also an en banc decision. And just as a little factoid about that case, initially the EEOC under Obama found that in prior cases, sexual orientation and gender identity were covered within the term sex, or term sex encompassed them. When we got to Trump, in the Zarda case, you had the EEOC saying, yes, Title VII covers sexual orientation and gender identity, but the Department of Justice intervened in the suit and said, no, it doesn't. It only covers the sex you are assigned at birth, and not sexual orientation and not gender identity, because the statute doesn't have those words in it. It only has the word sex. So sorry, I will stop. Shannon, you want to take it from there, what the court did?
Yes, but I'm glad you talked about Hively. That was really, Lambda did such an amazing job on that case, and it was very important. Hey, one of the cool things I think too about this whole history that we're talking about is, and hopefully that's coming through, is that it's actually been really helpful that we're an LGBT movement. The cases about gender identity and sexual orientation have really pulled each other along. Like transgender plaintiffs did really well first, and that helped create a favorable judicial climate for the sexual orientation cases, Hively and Zarda. And the EOC also agreed that Title VII should be viewed as protecting lesbian, gay, and bisexual employees too. And if you look at those decisions, they really draw upon the transgender decisions. So it's been really affirming, I think, to see that. I think it was a good, not only was it the right thing to do, but it was also been strategically really smart and helpful that we're all in the same movement together and talking about the commonality of the discrimination being really based. It really is, it's gender based, and that's just a really important kind of tie holding us all together, and the courts have seen it too. Yeah, well, the decision, when the Supreme Court took these three cases, we were all very nervous about it because it's a really conservative court, like extremely conservative court. And I don't think I'm telling any secrets when I say that we're pretty surprised to get such a positive decision, and one that was joined by 6 out of the 9 justices. Like, it's a 6-3 decision. We've never gotten that before. All of the other big cases involving LGBT people have been 5-4 decisions, like very narrowly decided, and we just win by 1 vote. This one was authored by Justice Gorsuch, who, of course, everyone knows was a Trump appointee and is extremely conservative, and was joined by Chief Justice Roberts, who was also extremely conservative, and I'm sure everyone remembers was so hostile, appeared to be so hostile to our community in the Obergefell decision. So having this decision be written by Gorsuch, a conservative justice, joined by Chief Justice, and then the usual more predictable more liberal justices joined the decision too, of course. That is so powerful. I mean, really, I can't say enough about how much that's going to help us in the future going forward, because this decision has like the stamp of such a strong, it's like a super strong show of support from the conservative side of the court, which will help us below with with conservative federal judges who are going to be much more inclined to be faithfully apply this decision. But in terms of what the court held, it is as simple, as perfect, as direct, as straightforward, as unambiguous, no loopholes, no qualifying language, as it could possibly be. I mean, the court just said in flat out that discrimination because a person is gay or transgender is sex discrimination, period, plain and simple. Because you can't, as the court pointed out, and as Shelley was talking about too, you can't even identify a person as being gay or lesbian or bisexual or transgender without, if you were, as the court said, if you were described to anyone, what does that mean? You will use the word sex, or you will talk about the person being a man or a woman. Like, you cannot avoid it. Like, it is a sex-based characteristic. And so that was the basis of the court's holding. And I know, Shelley, I don't want to jump ahead, so tell me when the time is right, or maybe you want to talk about this first. That not only does that mean that our entire community is protected, has workplace protections now everywhere, including in Texas. And I got to say, somebody living in Texas, that feels pretty darn good. But it means that all the other federal sex discrimination laws now have to be interpreted that same way. But I might be jumping ahead, Shelley, so let me kick it back over to you.
Yeah, let me just add to that. So there are about 100 federal statutes that use the word sex. And so now the court's opinion that previously have not necessarily been interpreted by the courts to cover sexual orientation and gender identity. And so now with the United States Supreme Court's decision, it's going to make it much more likely that those statutes, which include some really, really important ones, Title IX, ACA, so the Affordable Care Act. We've got the Housing Act, which is especially important for seniors. And you've probably seen there's been some Lambda cases and I believe some NCLR cases as well, where we have gone to bat for LGBT seniors, trying to make sure that they are treated the same and similarly to other folks and not discriminated against. So that's really, really important. And there's a couple things I just want to point out, some really good language in the opinion. I just gave a 2-hour speech about this about an hour ago or less than that. And there's some really good language that Justice Gorsuch has. And so and I also think even in the dissent, Justice Kavanaugh. So I think in so many instances, we have really not been seen for our humanity or not been seen for our, what I'm going to call political powerlessness. Lawrence v. Texas, Obergefell started that. But here's some language right out of Gorsuch's opinion. So regardless of how you read his opinion, I think he stuck with this, and I think it was a reminder to the courts. Let me read this because this is big. He says, but to refuse enforcement just because of that, because the parties before us happened to be unpopular at the time of the law's passage, would not only require us to abandon our role as interpreters of statutes, it would tilt the scales of justice in favor of the strong or popular and neglect the promise that all persons are entitled to the benefit of the law's terms. So I think for the court to say that, and it cites won't get into the legal part, but I think that's a really huge thing for the court to recognize, that it's there to be the champion of those fundamental rights, even though this was not a constitutional case, and equal protection to ensure that even if we aren't popular, we're all treated similarly. And Justice Kavanaugh has some great language at the end of his dissent that's very similar. So I think those are positive things. And I think that Shannon and I would probably both say that we were pretty darn worried after we listened to the oral arguments about what the court might do, because the justices didn't seem to understand the difference between gender identity and sexual orientation. And they were raising things about bathrooms and sports and, sexual predators. And it seems like that's a narrative that the lawyers really need to make sure, and the community as a whole, we need to educate each other about what these terms mean and where they overlap and where they don't. So Shannon, I'll turn it back to you. We've got a few minutes. Let's talk about what maybe the religious piece and what happened yesterday. And then
Okay, sure. Yeah, and just super real quick to just piggyback on the last thing you said, it is pretty wonderful to read that decision and just see how matter-of-factly the court talks about. They use examples to show that this is sex discrimination, like if Bob is married to Sally versus Mary being married to Sally. It's so clear that the fact that same-sex couples can marry now is so deeply ingrained in our society that even these really conservative justices just talk about it like, yeah, of course. And they're really, really sympathetic the way they talk about the transgender plaintiff in the case. Such a stark contrast to the oral argument. And in that oral argument, it just seemed like they were really uncomfortable and didn't really get what it meant to be transgender. And they talked about their language was very awkward, and they didn't necessarily always refer to Amy Stevens consistently as female. Well, none of that. The decision is just perfect. It is perfect. And the way the court talks in particular about Amy Stevens is so moving. The decision's very dry. It's a nitpicky, logic choppy decision because that's the textualist framework that Justice Gorsuch takes. But the one paragraph where they talk about Amy Stevens is very warm, and they talk about her loneliness and despair, and it's really quite something. Just the humanity of LGBT people comes through so clearly. But yeah, one of the big questions going forward is, now that we have this nationwide federal workplace discrimination, will the court start creating new religious exemptions to those protections? And there was a decision yesterday that did that, that held that religious schools, and I would also apply to other religious employers, but in particular, religious schools basically don't have to comply with Title VII when they are hiring teachers who at least have some duties to teach religion. If that's part of their job duty, then the court said, nope, you don't have to comply with any anti-discrimination laws. The plaintiffs in the case that the court decided, they weren't LGBT people. One teacher had alleged age discrimination relevant to this group, and another had alleged disability discrimination because she was fired after she told her school that she had breast cancer and was going to have to take some time off for treatment. So it's pretty intense to think that the religious schools just the teachers in those schools, and that's like a lot of people, tens of thousands of people, many of whom are LGBT now, just don't have federal anti-discrimination protection. So that was pretty big deal. Shelley, what else should we say about that?
Yeah, I was actually listening to NPR last night, and they said there's about 149,000 teachers who teach at religiously based schools. And so, what to kind of couple on what Shannon said, what this decision means is that if you teach in those schools, even if you're not responsible primarily for teaching religious based, curriculum, you might be a math teacher, you might be a coach for that matter, but that means that those religiously based institutions can fire you, refuse to promote you if they find out you are lesbian, gay, or transgender. And so basically, it's absolving those religious institutions of having to comply with civil rights laws. So this is kind of this is what I would call this is a big change, because for so many years, based on race, the courts have said, look, if we're going to look at the difference between, and I'll try not to talk too much longer, but if we're going to look at religion, and then we're also going to look at fundamental rights, equal protection, and due process, you're always going to find that religion is going to have to cede to those fundamental rights and equal protection. But now what this looks like is, and with the conservative makeup of the court, it looks like that pendulum, whereas used to be civil rights were more protected, might be shifting back towards protecting religion. Is that, and so that's going to be a problem for us going forward. Now, I'll say one more thing. We can get married and go into work and not get fired, but now we've got the religious piece to handle, so, or to deal with. So Shannon, maybe talk about that, and then we'll take questions.
Yeah, I mean, I don't know there's much more to say about it than what you've said, Shelley. I mean, the decision yesterday was a big change. On the positive side, it does apply only to religious employers, and really primarily to religious schools. And we just have to, remains to be seen, the court is going to continue to create sort of sweeping new exemptions or exceptions to anti-discrimination protection. I am cautiously optimistic, to be very alert on this, very vigilant, but I'm cautiously optimistic that they won't go too far down that path, just because it would be so destabilizing for the law and really for our whole country. But it's definitely something to keep an eye on. Before we go over to questions, which I'm really eager to do, I did just want to mention one case, because Shelley, you alluded to it, the housing protections, which are so important for LGBTQ elders in particular. And I just want to mention one case that's we're already seeing a positive impact, which is NCLR has a case that we brought in Missouri on behalf of an older lesbian couple who needed a retirement community that provided some medical support. And they were in the process they found the one they wanted. It was perfect. They were in the process of applying. They'd already put their home up for sale, and they were far down the road and, getting into this community when, but apparently the owners didn't realize they were a married couple. They thought they were sisters or something like that. And then when they found out that they were a married same-sex couple, they're like, oh no, we don't allow any same-sex couples in our community. So it was really overt, blatant discrimination, which I think unfortunately is still really, really common. We just see that a lot. And when we brought a case under the Fair Housing Act, which prohibits a federal law that prohibits sex discrimination in housing, we lost at the district court level. The court was like, nope, sex discrimination is one thing, sexual orientation discrimination is another. You do not even have a claim. We appealed to the Federal Court of Appeals. They put the case on hold. They're like, well, let's see what the Supreme Court does in Bostock. Right after the Bostock decision, the defendants in that case, the retirement home, they actually said, hey, we know we're going to lose now. So they voluntarily told the Federal Court of Appeals, just send it back to the district court for entry of judgment, because we know we're going to lose, because the Fair Housing Act is interpreted the same as the Title VII. So that was really encouraging. But I think that anyway, the case is just a good example of how important this decision is going to be for our community across a whole broad range of areas, including housing. But let me stop there, and I hope people have questions.
Yeah.
Great. If it's time for questions, everyone, then I want you to know we have so many people on this meeting that everyone is automatically muted. So would you please look at the bottom of your Zoom screen and you see the word chat. If you'll click on chat, you can submit a question and we will start. Shannon, I want to respond to what you just said. We've done extensive research at the Coalition for Aging on the question of LGBT acceptance inside retirement communities. And what we found is that 99% of the time, you get an answer that's very affirmative. Is my mother and her wife welcome here? Absolutely. But we came to find out that we got that response because we were talking to the sales manager. And the reality, after you get past that first layer, can be very different.
We, another plug for Lambda, we brought a case in the Seventh Circuit. It's called Wetzel, W-E-T-Z-E-L. And in that particular case, there was a gal who was treated just horrifically once she said that she was a lesbian, treated poorly by the staff, treated poorly by the other residents. And in that particular case, under the Fair Housing Act, the court actually said that the nursing home or the long-term care facility where she was, the staff knew, and because she had also been complaining about her treatment, that the nursing home was responsible for what the other residents were doing and how they were treating her. And that case ultimately was going to go a little bit further, but we won. So that's another great result in trying to make sure that those, we're just like Robert said, it may look great on the outside. It's just like something shiny new that you go buy and you get it and it doesn't do everything that it's supposed to.
And Brianna Monsalve is the administrator for the Coalition for Aging, and she has received a question. Brianna, would you like to read that first question?
I certainly can. One of the questions that we received is, are there any additional cases concerning LGBTQ protections that show promise on their way to the Supreme Court in the near future that we can be on the lookout for, that we might want to know about?
Well, Shelley, I want to see what you have to say about this too. There are definitely cases out there that involve some of the statutes that Shelley was speaking about, Title IX, which applies to education. So there's cases out there in particular about transgender students that are in the pipeline. There's Fair Housing Act cases, as we just noted. There are definitely Affordable Care Act cases, because the Affordable Care Act prohibits sex discrimination, and that means LGBTQ people cannot be discriminated against by insurance plans or providers. So there's several cases out there that are litigating under that statute. I hope that we don't need for any of those cases to go all the way up to the Supreme Court, because what I hope is that the federal courts are going to follow Bostock and just be like, yeah, these laws protect LGBT people, and if they do that and there's no conflict, then we don't need the Supreme Court to weigh in again, which that would be the absolute best thing. And if there's a new administration that's not hostile to our community as the current one is, I'm sure that a new president would order all federal agencies to just implement Bostock, which would be great too. So we'd have the administrative enforcement agencies and the courts hopefully just doing the right thing and protecting our community. But Shelley, what do you think? I mean, maybe should we mention Fulton? I don't know. Shelley, you're muted. Sorry.
Oh.
Sorry, I muted myself instead of unmuting. um, so there's a couple of cases I think that everybody should watch. One is the City of Philadelphia versus Fulton. It'll be decided next year. And this is another one of those, tension between religious-based exemptions and LGBTQ folks. And so the City of Philadelphia has a non-discrimination ordinance, and it has a contract with the Catholic Diocese for foster care and adoption of children. And the diocese has started saying, look, we're not going to allow same-sex couples to foster or adopt. I'm oversimplifying it a little bit, but that's just because this is what it's really about. Lawyers like to use a bunch of big language, which is really boils down to common sense. But so the diocese is saying we're not going to allow same-sex couples to foster or adopt. And so that case is now pending before the Supreme Court. Lambda also has a case, despite the recent opinion in Bostick. President Trump said we're going to roll back protections for LGBT folks in administrative law. And that particular rule came through on Friday, and Lambda filed a suit on Monday saying, based on, especially under Bostick, this cannot be, meaning that the Affordable Care Act does have to cover sexual orientation and gender identity because of sex. I think that's fair. Do you think that's fair, Shannon?
Absolutely. Yeah, you betcha. Yeah, I mean, look, and to my mind, there's the healthcare is so important. I was gonna say the most important. Everything's important. So, but being able to, go into a hospital or go see a doctor and know that you can't be turned away. I mean, that is so important. And I know we're here in Texas. Like, I live in fear of that every day about what would happen as a transgender person. What if I had to go to the hospital around where I live in rural East Texas? I really worry about it. So, those Affordable Care Act protections are so critical, and I'm so glad y'all brought that case, Shelley. And, same with the long-term care facilities and all that. And Robert, I was so interested in what you were saying about when you talk to the sales rep, everything's great. But I mean, we all know, I'm sure every person on this knows of somebody who's had a bad experience, as an LGBT elder. And I think about my family members who are not LGBT, and we're in the ones of them who are in care facilities. I cannot imagine those facilities being open or supportive of a same-sex couple or a transgender person. Like, we have so much work to do on this. And I'm so appreciative of this group. And I know you all are working on it, and I'm really glad you are. We have a long way to go on this one.
Matt Roberts, who's with us today, he says, unfortunately, we all know not feeling welcome there is problematic. However, having the legal precedent for the right to be there is critical. Kim McPherson asks, do you foresee a case involving LGBTQ workplace discrimination within a religious school or business?
Oh yes, they're out there.
Yeah.
They're already out there. And one of the unfortunate results of the decision yesterday is that most of the cases I'm thinking of where an LGBT person is employed by a religious school and has been fired because of their sexual orientation or gender identity, and then has brought a lawsuit, they're bringing them mostly under state law, state anti-discrimination laws. And now, after the decision yesterday, which relied on a constitutional doctrine, which is called the ministerial exception, it's just jargon, but anyhow, it is constitutionally based. That's going to override any contrary state law. So it's going to be tough. Yeah, I'm sure we will continue to see LGBT employees who experience discrimination by a religious school will bring cases. They will bring cases. And I don't think we'll lose them all after yesterday. It's just that the court is going to be more of an uphill battle after yesterday. I mean, it's going to come down to whether they're in a position that's where part of their job entails an important religious function. That's what the court held yesterday. If part of your job is religious, then the school gets a pass. But, is that going to apply to somebody who's like a janitor or a receptionist or a librarian? Hopefully not, because I think usually you don't think of that as playing a per se religious function, but that's going to be where the fights are and the conflicts.
Just to briefly add, there's a piece of legislation pending before Congress that was first introduced in 2015 in both houses and had tons of support from businesses. It's called the Equality Act, and it was recently reintroduced again and is, passed with flying colors more or less in the House. We've just got to deal with the Senate. And what the Equality Act would do would be to add sexual orientation and gender identity to the Civil Rights Act of 1964 and to expand the places within which discrimination would be prohibited based on race, color, religion, national origin, age, sex, etc. And it would expand it to things like healthcare facilities, retail stores, banks, the ability to go get credit. And it would also, by the way, for us women folk, whether or not you're LGBT or not, it would help us and give us protections that we don't currently have that we can be discriminated against. So Shannon can go try to buy a car and get a much lower interest rate than me simply because Shannon's a man and I'm a woman, even if we have the exact same credit score and look the same on paper. And I think Robert would point out to y'all, as you probably know, that folks who do go seek housing, LGBT couples, or once people are found out to be LGBT, 48% of them, they have to pay more for their housing as seniors, they have to go through more hoops, there's more things like that. So even though the court has ruled the way it's ruled, hearts and minds take a long time to change, and you can see that with the Civil Rights Act of 1964 and where we are with Black Lives Matter.
Perfect. Thank you so much, guys. We have a couple of questions came in relative to Title VII. First one is, will people who have lost jobs in the past be able to get their jobs back? Meaning where it's important for folks protecting their retirement pensions and funds. And the second question is, let's see, it is how does the decision intersect with the Trump executive order and court decisions on the Affordable Care Act?
Sure. So, and then Shannon, please chime in. So with respect to can you get your job back, I think that the decision is going to be read retroactively to at least go back in time at least 6 months. So when you are discriminated against, you have to bring a claim with the EEOC within 6 months. So to the extent that you've been discriminated against then, within the last 6 months, I think you probably have a claim. Can you go back in time further? I'll let Shannon kind of address that. That's a pretty sticky legal issue, and typically there's some legal doctrines that would prohibit that because this is not a constitutional case. If it was a constitutional case, those legal doctrines wouldn't be there. So that's that piece of it. And then the second part was the Trump's latest rule, which is a little bit about what I alluded to before. That is the rule that Lambda filed the lawsuit on. The rule went into effect on Friday. We filed the lawsuit on Monday. And so we are claiming now that that rule cannot go into effect for that very reason. And so that is that exact case. So the other thing I would say too, just briefly, is y'all don't mistake that there are groups out there, and I know we're available on Zoom, but there's a group called Alliance Defending Freedom. There's another group called the First Liberty Institute that's right up here in Plano, Texas. And those groups are doing anything and everything that they can to ensure that we don't have equal rights, including students in schools, bathroom usage, sports, and they're filing lawsuits all across the country, and they have a ton of money. So we've got a lot of work yet to do.
Boy, we sure do, Shelley. Yeah, just on the pension benefit and retirement benefits. Oh my gosh, those are so important, and we have gotten so ripped off for just years and years and years, and it's so painful to think about all the money that should have gone to same-sex surviving spouses and partners that has not, and that is one of the most unjust aspects of workplace discrimination. That is one area, as Shelley said, like it's probably not going to be possible to go back in time and get a job back or something like that. But with the pension benefits and retirement benefits, there's more hope there because it's kind of an ongoing issue, and it'll depend case by case, and in some cases it'll be too late, but in some cases it won't be. So if you or anybody you know has any doubt or wonder about that, it would definitely be worth getting legal advice about that. And you could call our helpline or Lambda's helpline to get somebody to look at the specific situation. But that's one where it's quite possible that this decision may, help people who are being, mistreated, ripped off in terms of retirement and pension benefits. We have a bunch of those cases, actually.
So let me jump in one more time, and Shannon too. So Lambda has two cases pending. One for folks who are in long-term relationships and their partner, even if they weren't married because we couldn't get married, passed away prior to the Obergefell decision, and then seeking survivors benefits for those folks that would have gotten married had they been able to. And so we have a nationwide class action, and so far we've been winning in the lower court on that, and have gotten a good sort of favorable, a favorable decision so far. That's an Arizona case, and then we also have another nationwide class action. Class action meaning you can opt in for those folks who got married after Obergefell, but one of the spouses didn't live for 9 months, because under the Social Security Act, you have to live for 9 months before you're entitled to survivor's benefits. And so that case is also out there, and I know Shannon has them as well. And so far we've gotten good results in both of those cases. So if anybody feels like they've been in a long-term relationship and they want to go get some survivor's benefits, definitely reach out to either Shannon or ourselves, call our help desk, and we can plug you in.
Great. Matt Roberts, I want you to know, I see your two questions, and for the sake of time, I'd like to answer those directly after this session is closed. So keep your chat up. Shannon and Shelley, do either of you have a closing statement or an overview statement you'd like to share with us?
Okay. Yeah. I just want to say again how much it means to me personally, as a transgender person living in North Texas, to know that this group exists. And I just seeing your faces and knowing, being part of this event means, it really just, it means so much to me. And I'll just echo Shelley's theme for the day, which is we really have made incredible progress. I mean, when I think, I've been being a lawyer for 30 years, and when I think about the state of the law when I started and what it is today, it's astounding. I mean, marriage equality, now nationwide employment protection, all the states that are passing laws about conversion therapy, all this, the very positive family law decisions. People, for the most part, are no longer losing custody of their children because they're an LGBT parent. I mean, so many things have changed. And yet, particularly, I think, when it comes to issues affecting the two ends of the life cycle, youth and elders, we have so far to go. We have so far to go. And so, I'm ready to roll up my sleeves and really tackle those issues. I think the time has come. really think the time has come for our movement to really put issues affecting LGBT elders front and center in a way that we haven't done yet. We've had a lot on our plate, but now I think now is the time for that. So, yeah.
I agree with everything Shannon just said, and I'm going to plug Shannon for a minute. Shannon is very gracious, but Shannon has basically, from the ground up for the last 30 years, has been the force behind so many of the laws that now do protect us. And so you've got sort of a legend and a pioneer right in front of you who now is in North Texas. So you're going to be conscripted into the coalition, I'm just saying, or anything having to do with elders because of what you just said. And then the plug I would say is certainly please call Lambda's help desk. If you feel like something just doesn't feel right. Same for NCLR. Lambda has 4 dedicated attorneys that's all they do is to intake potential complaints and then parse them out where they need to go.
Shelley Skeen, you know that I love you for all that you do and for who you are. And Shannon, I'm so grateful you joined us. The Coalition for Aging LGBT has the word coalition in our name because we are dedicated to partnerships, to partnering with organizations such as Lambda Legal and the National Center for Lesbian Rights. The coalition will continue to have these events for you to attend for free. And the next one, please mark your calendar for Thursday, September 3rd, when we are going to hear from a certified financial planner to get us thinking about financial planning. Thank you very much for being with us. We are so grateful for your support of the Coalition for Aging LGBT and for Lambda Legal and for the National Center for Lesbian Rights. We appreciate you so much, and we look forward to seeing you on September 3rd. Good afternoon, everyone.
Thanks, everybody.
Thank you.